And now we're going to get to the actual Form 1 application for charter motion, abusive process, malicious prosecution, blah, 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 blah. So here's my concise statement of the subject of application. The prosecution is proceeding on the testimony of a witness who has already been found to have lied in prior court tribunal proceedings on a material fact documented by state records. The prosecution rests exclusively on the testimony of a complainant who has already been found to have lied in prior judicial tribunal proceedings, whose statements are contradicted and whose credibility is further undermined by post-charge destruction of evidence, yet the Crown continues in the absence of any independent corroboration. This is an application for charter relief pursuant to Section 24(1) of the Canadian Charter of Rights and Freedoms, including a stay of proceedings arising from abusive process, malicious and retaliatory persecution, failure of disclosure, and state conduct that has compromised the applicant's life, liberty, security of the person, and right to a fair hearing, contrary to Sections 7, 9, 11, and 15 of the Charter. The applicants displayed a handwritten help sign from his residence while seeking assistance and attempting to escape an abusive and unsafe environment. This conduct preceded in layering of charges and is relied upon as evidence of help-seeking behavior, not criminal intent. Shortly thereafter, charges were laid. At all material times, the applicant was an active litigant in multiple court and tribunal proceedings, including proceedings before the Human Rights Tribunal in Ontario, the Landlord and Tenant Board, and the Federal Court of Canada. These proceedings and the applicant's associated legal obligations, vulnerability, and whistleblower activity were known to the informant and to state actors prior to the laying of charges and form essential contextual evidence relevant to the abusive process and charter violations of protected whistleblowers under the Evidence Act. This application further seeks protective and procedural relief, including an order changing venue or otherwise removing the requirement that the applicant attend proceedings in Sault Ste. Marie Judicial District, orders permitting remote appearance only, an order permitting third-party retrieval of the applicant's property and evidence without personal attendance, and such further charter remedies as are just and appropriate pursuant to Section 7 and 24 of the Charter, arising from state-created safety risks, repeated interference with access to justice, and the foreseeable harm associated with requiring the applicant to return to a jurisdiction in which he has experienced nothing but documented danger, obstruction, and deprivation. The application is also brought to address a pattern of state obstruction of justice, including a refusal to receive or consider material exculpatory evidence, loss, destruction, or impairment of evidence, while the applicant was prevented from accessing his belongings, misdirected, delayed, and incomplete disclosure, continuation of proceedings despite knowledge of the applicant's protected status as an Indigenous, disabled, multi-marginalized whistleblower and active litigant. The applicant seeks relief to preserve trial fairness, protect personal safety and security of the person, create a complete and accurate record regarding state contact disclosure failures and prejudice, and to prevent further abuse of the criminal process inconsistent with the integrity of the administration of justice. The applicant will rely on a written brief of legal argument addressing inter alia, abusive process, malicious and retaliatory prosecution, failure of disclosure, improper reliance on uncorroborated informant allegations in the absence of independent physical evidence, state knowledge of vulnerability and protected status prior to prosecution. Here are my grounds to be argued in support of this application. Rules 2.1, Criminal Rules of Ontario Court of Justice, reliance on a demonstrably unreliable informant. The prosecution relies exclusively on the testimony of a complainant whose credibility has been materially impeached in prior tribunal and court proceedings. In Landlord and Tenant Board proceedings, the complainant denied the existence of a lease agreement despite having executed a written lease bearing her signature, which was subsequently produced by the applicant and accepted by Ontario Works and other state officials as valid. The Crown nonetheless proceeds without independent corroborative evidence while refusing to receive or consider documentary, physical, and third-party evidence that directly contradicts the complainant's account. Continuing a prosecution on sole basis of testimony from a witness already shown to have made false statements under oath constitutes an abusive process and undermines the integrity of the administration of justice. The applicant also relies on how the prosecution is proceeding substantially or exclusively on this testimony, who, notwithstanding that same individual, has previously provided demonstrably false materials, destroyed evidence, and was under the full awareness of made applications and full vulnerability risks of the complainant. The applicant will rely on this documented inconsistency as evidence that the prosecution's continued reliance on this witness in the absence of independent corroboration and in the face of contrary documentary proof constitutes an abusive process and undermines the integrity of the administration. The applicant relies on the following grounds in support of application. Mr. O'Neill relies on made applications from 2021 and 2022 as evidence of severe pre-existing state-linked harm and foreseeability. The continuation of proceedings and state conduct compounded that harm, engaging Section 7 and Section 24 violations. Abusive process, the conduct of police and Crown taken cumulatively, undermines the integrity of the justice system and renders the continuation of the proceedings unfair and oppressive, warranting relief under 2.1 in the Charter. Malicious and retaliatory prosecution. The prosecution was initiated and continued after the applicant reported abuse, sought protection, and pursued lawful remedies against the complainant and state actors, demonstrating an improper purpose and retaliatory motive in the absence of reasonable and probable grounds. State knowledge and foreseeability. Prior to and during the prosecution, state actors had known actual knowledge of the applicant's indigenous identity, disability, sexual orientation, and multi-marginalized status, whistleblower and informant activity, active court and tribunal proceedings, housing instability and vulnerability. Despite this knowledge, state conduct foreseeably placed the applicant at risk and impaired his ability to comply with justice system's obligations. Failure of disclosure. The Crown has failed to provide full, timely, and accurate disclosure, including serving disclosure to a correct address despite notice of the applicant's correct address, thereby impairing the applicant's right to make full answers and defense. Evidentiary imbalance and selective reliance. The prosecution relies primarily or exclusively on uncorroborated allegations from the complainant while refusing to receive, review, preserve, or acknowledge extensive physical documentary evidence by the defense and witness evidence tendered by the applicant. Interference with access to justice. State actors interfered with the applicant's ability to participate in active legal proceedings through deliberate disruption of housing and internet access, obstruction of access to property and evidence, resulting in missed hearings and procedural defaults not attributed to the applicant. Number 7, destruction, loss of impairment of evidence. While the applicant was unlawfully prevented from accessing his belongings, material evidence was destroyed, lost, or impaired, causing irreparable prejudice to the applicant's defense and related proceedings. Charter violations. This is by Carrie Oliver, the only one that they're relying on. The testimony, the only one that they're relying on, and they let her destroy all my evidence, and they're still relying on her testimony after everything she's done to me on record and all the lies that she's given to court. Okay, that's like embarrassing. That's enough to take the whole office down, because if they're going with that, the whole office is compromised. Charter violations. The applicant alleges violations of the Canadian Charter of Rights and Freedoms, including Section 2A, freedom of conscience and religion, Section 7, life, liberty, and security of the person, including state-created danger, Section 9, arbitrary detention, Section 11, right to a fair hearing and presumption of innocence, Section 15, equality rights with remedies sought under Section 24(1). Number 9, state-created danger through bail conditions, housing displacement, denial of protection, income degradation, and failure to respond to known risk. The state affirmatively placed the applicant in foreseeable danger, engaging Charter 7.7 violations. Reasonable apprehension of bias. The continuation of proceedings in the current jurisdiction in light of documented conflicts, procedural irregularities, and state contact gives rise to a reasonable apprehension of bias and foreseeable prejudice to the applicant. Necessity of protective and correlative or corrective relief. In light of the above, protective procedural orders, including relief under 2.1 and the Charter, are necessary to prevent further prejudice and to preserve the integrity of the administrative justice. Number 12, the prosecution relies exclusively on the, I don't think I said that. In prior proceedings, okay, despite the documented contradiction, Gary's talked about that. I think I did that double. Anyways. The Crown has refused or failed to receive, preserve, or meaningfully review extensive documentary, physical, or timeline evidence from me. The continuation of prosecution is going to violate all these things. Mr. O'Neill relies on I think I just copied that. I copy and pasted that twice. Must have. Okay. So that's part 1 and 2 of my Form 1 for my charter violations against the Crown.